Hi, everyone. Thanks so much for joining us today. My name is Hillary. I'm here with Maine Access Points, and we are really lucky to have another Hillary with us to talk about legal rights and harm reduction. Just a couple points before we get started. If there are any tech issues, we will definitely get live again. We would love for this to be a conversation and a discussion. And so feel free to use the comments and chats to ask questions. And, you know, I think just something really important to state is that this is a conversation kind of like on big concepts, on legal education, and Hillary is not here to give legal advice. And so she'll talk a little bit more about that. But certainly if you have questions or thoughts, feel free to share. What else? You know, I think anytime we do education at MAP and have conversations, you know, we just like to recognize that we all have a wide range of lived experience, and sometimes conversations can just bring things up. Like certainly we're going to be talking about criminalization and systemic harm and violence at times. And so for sure, if you need any support, you can reach out to the MAP team. You can reach out to us at 207-319-8823. That phone number is connected to me. You can signal, call, or text. And I'll put that message in the chat right now, that phone number in the chat. Hillary is going to be able to put together a bunch of resources for us, which is really exciting. And so we can, we'll have that up on our website in the resource section in like a week or so. So definitely take a peek for that. We'll make it known on social media as well. And, you know, we have another education opportunity in our series coming up on June 18th. We're really excited to have a member of our distributor team, Kate, having a conversation on harm reduction, reproductive justice, and pregnancy for birthing folks. And again, that'll be on June 18th at 12 p.m. So that's about it for now. You know, sometimes we take the whole hour and a half on these conversations, sometimes we don't. So we'll just kind of play that by ear. And you can always go back to our YouTube channel to view this again. So we'll have this up and available ongoing. I can't think of anything else right now. As you ask questions or give thoughts, I'll make sure that Hillary also sees them and make sure that they get raised. Your questions get raised. I think that's it. So Hillary, on to you.
Yeah. Thank you very much. So I have a rough little outline here. And I just want to start out, I think, by saying why I feel like I'm here right now. I just want to be helpful. I want people to understand their rights, but most importantly, to understand that they have the right to know their rights. So I want to sort of introduce some opportunities to know where to look to find information primarily. It's kind of impossible to tell you everything that I can. And I would love to just go on and on. I love talking about this. So like Hillary said, I can't give any specific legal advice, and every single case and every single event is really specific to that person and to that moment and those scenarios. So this isn't, you know, particular cases or particular examples. It's big concepts, and I really want to encourage anybody who's got questions, big or small. There's no judgment whether you know something or not. I think that I think I was joking with you, Hillary, the other day that I think lawyers sometimes act like the law is a secret and that only lawyers know it. And I just think that's not true. And I want everyone to know where they can find these information. So I'm flexible. We can jump around. You just tell me what's useful. But I thought I would just start out a little bit so you know who I am. And before I talk about who I am, I put up these bad lawyers because I wanted to recognize first and foremost that I'm a lawyer. I love being a lawyer, but lawyers can also cause a lot of harm in people's lives. And there are lots and lots of people who have been harmed in their interactions with their lawyers or have felt like they did not receive good representation or advocacy from a lawyer. And so I feel pretty strongly that I haven't earned anybody's trust yet. And so nobody owes me their trust or faith. And I really recognize that my jobs have been within the system. I'm a person who works very much in a system. And so if that system has been harmful to you, I can really empathize with the feeling that lawyers are not, helpful or that you might be better off on your own. I can empathize with that feeling. And so I just wanted to recognize that I have my lane and I feel like I know what it is. I'm not a policymaker or a legislator. I represent individual clients in individual cases with the law being what it is. I'm typically not trying to change policy or advocate for changes, reforms, that kind of thing. Maybe personally, I might feel like something should be reformed, but my job and my work is about trying to help people with the current status of the law. So that's really my specific role. And I just wanted to also transition a little bit from me to why I'm here. I found harm reduction through my work as a public defender. A little bit about me. I'm from Maine originally. I went away to school. I lived in Massachusetts for 12 years with some stints in other places. And I lived in Western Mass, Eastern Mass, and then I settled after law school. My first job as a public defender in Worcester County. If you've ever been through the city of Worcester, it's a great place. I really love Worcester, Mass. It is the second biggest city in New England after Boston. It's a huge, huge, huge city. But Worcester County goes from the southern border of New Hampshire to the northern border of Connecticut, and it really just divides Massachusetts in a third. So it's an enormous area. And the city of Worcester is a big city, but the county also has just every kind of little town, little city. And so it was a really great place to learn how to be a lawyer and start to learn the law. But what I also found during my first years as a public defender was harm reductionists. And that really informed my sort of philosophy for representing clients. And so I pulled some of these principles from a few of the harm reduction sources, because these are principles that I really carry with me in my work. And I wanted to lay them out for you so that sort of like as a foundation for the conversation. I think when we talk about knowing your rights and how to interact with police officers or courts, there's sort of a gap between the written, I know that I have the right to remain silent, and real life when it doesn't feel practical to literally just not speak. And filling in those gaps with real life experience, I think, requires us to first and foremost just try to minimize harm. And the way to do that, I think, is to allow people with lived experiences to guide us first and foremost. And to never shy away from the fact that these can be really harmful interactions and that these can be really dangerous interactions. I don't think it's productive to ignore those realities. And so being compassionate and listening and learning more than anything else is where my value is, I guess, as a lawyer. So I just wanted to highlight that. It's a little intro about me. I want to just start with a little bit of a lay of the land, if that's okay, some real basics. Like I said, not everybody gets an opportunity to learn all of this stuff. And even if you do, maybe it, wasn't something that stuck because you didn't need it. And so I just wanted to offer a couple of initial roadmaps for us. Kind of like, I guess, at the beginning of a book, maybe when they have a map of where we're going, I just sort of wanted to lay out where the places are that we might be talking about in the law. So last thing I'll say before I talk a little more specifically is just that I feel really strongly that every single person who could interact with the courts or police, you have the right to understand the system, right? You have the right to understand what's happening to you. And it can take a lot of courage to say, I don't understand what's happening to me right now, and I want somebody to explain it to me. So that's a right that I just really believe in, is to be able to say, hey, I don't get what's going on. I need somebody to explain it to me. Nobody should feel like you don't understand what's going on down the street at your courthouse, at the courthouse in your town. They operate all day long, every single day, and people are in and out. And if you're there for the first time, you may not recognize the people there. You might not know, which offices you need to visit. And people who do work there every single day, a day in and a day out, forget that other people aren't familiar with those spaces. So asking questions and how to ask questions is just the bravest but most effective thing you can do.
Yuri, that's something that I really appreciate that we've had a lot of conversations, is that at any moment in, someone's experience being in court or having conversations with lawyers before that, it really is within our rights to say, please stop. I'm not understanding what's happening right now, and I need you to slow this down for me and explain. Because I think so often in these moments, like you said, people, this is their everyday. You go to court every day, you're going through these motions, and for someone else, it may just be really confusing, and it's our right to know that. And I think that, providing opportunities like this to have these conversations preemptively is really powerful and meaningful, but also that we can do it in the moment. We can stop in the moment, and at any given time, there should be someone there to answer our questions, even if someone is incarcerated, even if court is happening in that moment, or we're waiting for a court date to occur. I really appreciate your, the power that you give back to folks to say, stop, what's happening right now, and where do we go from here?
And we'll talk a little bit more about working with attorneys, but I think especially if you are represented by an attorney in a case, it's the most important thing is that you have enough trust in that person that you feel like you can ask them your questions. You should not be making decisions about a court case that you don't understand. And so if you have questions and you don't feel like you can ask your lawyer those questions or talk openly with your lawyer about your concerns, then there's a real problem. And we'll talk a little bit more about kind of situations like that, but it's absolutely a lawyer's job to make sure that their client really understands what's going on. And so when there's a lot of pressure to move, just get this case over with, let's go on to the next case, like you said, kind of putting a stop in there, kind of just creating a little bit of space between events so that we have an idea of what's happening. I think that's my role as an attorney, is to make sure that at each stage, my client understands what's happening. Okay.
And just a reminder to folks that are viewing this, please do ask questions. If there's something that you would really like us to discuss, Hillary can definitely have that conversation now, or if it can't happen right now, we can certainly link you to the information that you need another time. Thanks.
Absolutely. So I wanted to just quickly frame up this idea, this distinction. And I did this because I want to just recognize something that is true in the world. So wherever you are in the United States, you are protected. You have certain rights that are protected because you are just within the borders of the United States. You also have certain restrictions on your behavior. There are certain things that you cannot do because you are underneath the jurisdiction of the United States. So criminal laws, obviously, those are the behaviors that are restricted by our laws. But we also have state laws and all these other forms of restrictions and rights that are given to us. And so before I kind of break those down a little bit further, I wanted to just distinguish that I'm going to be talking about legal systems. And by that, I mean the American and state and federal court system. So there are lots of rules, regulations, restrictions on people's lives that are not within the sort of legal system that I'm talking about, but that really impact our behavior and how we make choices in the world. And so just because I'm talking about legal systems does not mean that I am ignoring or disregarding the fact that there are other regulatory systems in the world. So I just wanted to focus that just so that it doesn't feel like I'm skipping over, real life. Because often I think when I go into court and I'm reading cases, or if I'm presenting an argument, it feels like very separate from real life. And I just want to recognize that sometimes it does really, really feel that way when you're talking about these things. So this is my attempt to just demonstrate. We've got legal systems, legal rules, and we also have extra legal or extrajudicial things that happen in our lives. And yeah, so this is a little bit of a kind of an example, right? So when I'm talking about legal systems and the laws that affect our lives every single day, they come from a million gazillion different sources. So we get some of our basic fundamental rights from the US Constitution. We also get them from federal statutes, right? We get them from federal laws that are passed by Congress. Those laws can authorize other parts of the government to issue regulations, which might impact your life or might restrict some behavior. You might enter into a private contract, like a lease or an employment contract, and that contract might have restrictions and rights that it gives to you under law, right? Court orders, if you are served with a restraining order, that order itself has basically created a rule that restricts your behavior. Our courts also create laws by interpreting statutes and the Constitution and issuing decisions on specific cases. So case law can also become rules that impact us or rules that give us rights and freedoms that are protected under law. Also, when you participate in government programs, so if you are a recipient of public benefits, your behavior, your eligibility might very much be determined by rules and restrictions that are specific to that program. And then, of course, there's just cultural, religious, community norms, expectations, things that impact our behavior, because if we were to violate those norms or those rules, something bad could happen to us. It might not be a legal rule, but it could very much be an important rule in our life. So I just wanted to sort of recognize there's this whole framework of different restrictions and protections on our behavior, and they don't all just come from one source. They come from all kinds of different interactions. So I have found that it is the case that the less money you have, the more restrictions you will experience. And when a violation of a restriction, a legal restriction, is alleged against you, if you are low income, I have found, and I think statistics back this up, that you are more likely to have those rules enforced against you, as opposed to just having let something slide. You're more likely to experience a harsher penalty or a harsher punishment. And that can be because for all kinds of reasons, but one simple example would be fines. If you're fined $100 because the statute says that's the fine for that offense, $100 just means different things to different people. So I think that money can often be the number one thing that increases the level of restrictions in your life, legally speaking. And important to me because I've only practiced law for low-income clients. And so I see this happen kind of a lot over and over and over. And I just wanted to sort of recognize that each person kind of walking around in the world has an entirely different universe of rules and restrictions that might be acting on their person, right, on their decision making. So back to basics a little bit. We have laws that come down from the government, but from different branches of the government. So we've got a 3-branched government at the federal level and a 3-branch government at the state level in Maine. I am, again, just talking about state and federal rules here. There are other jurisdictions, indigenous nations that might not have a 3-branch local government system. Mm-hmm. But for now, I'm just going to talk about Maine and the federal system. So we get our laws, right, primarily our statutes from the legislative branch. The judicial branch, the courts, hear controversies between individuals, but also between individuals and the government. And the executive branch is responsible for administering the laws. And so I have found also that the executive branch is often where our lives are most visibly impacted on a day-to-day basis, because the executive branch enforces rules through its agencies, right? So often through these big agencies at the federal level. That might be Department of Health and Human Services. It might be the CDC. It might be the FBI. And at the state level, you've got same thing, DHS, executive agencies. The police, state police are an executive agency. And so it's just kind of good to frame ourselves back to where each rule comes from and how they interact with each other, because we'll come back to that a little bit. I just want to pause real quick and just give you a sec if there's anything you wanted to.
No, I think that this is, I really appreciate this, like kind of having the basic understanding as we kind of delve into some of the more specific conversations for today. I think that having that knowledge of how laws are made and also in the recognition in this conversation that we all experience those laws in really different ways, based on, the drug war, on the war on poverty, on, racism, how we kind of like intersect with laws can be a really intimate and really harmful experience. And so I think, a lot of times when we have this education, that's really left out of it, so that, you can be saying, this is your right, and someone saying like, yes, I understand that's my right, but I've never experienced having that human right. I've never experienced the law protecting me, or I'm constantly experiencing criminalization. So I think I appreciate you kind of like grounding us in the beginning of this conversation.
Well, and it can be, like I said, really disorienting. I find that when I see something happening in court that feels like it does not match up with my understanding of the laws, it is jarring. And so that happens to me all the time, because it just does. And I don't think I'm used to it. I'm not desensitized to that. It still kind of rattles me when I feel like a court decision doesn't really line up with my understanding. But it's especially disorienting when you're the person who's impacted, right? Who's been hauled into court, or who's been, and especially when you're thinking about, I've been told I have the right to remain silent, and so I didn't say anything, and now I've been accused of a crime, and they took my silence as suspicious, right? So there's a bunch of examples. I don't want to get too far ahead of myself. This is my bad habit of diving in. But you said something else that I just wanted to touch on, which is this overlapping nature of the rules. And if we have time at the end, I would love to talk a little bit more about the way that the war on drugs has just like a million tentacles. It goes into all of these different areas of the law, and federal regulations, agency regulations, you see the drug war just every page. It's, convictions for drug possession can bar you from so many programs, benefits, entitlements, and it's all rooted in this like one idea that the way to resolve the drug crisis was to criminalize, but not just criminalize, but also to create these life penalties, these ramifications that sort of ripple out through your life into housing and employment and income, and it can impact everything. So we've framed this up a little bit. Let me just zoom in one more step lower, which is through our court system. It's a dual system, at least to the extent that I'm talking about it here. On the left side of the screen is the federal court system, and on the right side is my best attempt at the Maine court system. And I just wanted to point out that they don't really overlap. These are two separate jurisdictions. Now, con law is not my strong suit necessarily, but I do want to point out there's really two parallel systems happening, and they rarely, if ever, cross over. And in yellow on the left side, you see the trial courts, the federal trial courts. And so that's where you would have, if you go all the way to the left, you see U.S. district courts, 94 courts, including 3 territorial courts. That is where you would be handling just a trial court level federal case. So if you were charged with a federal crime, that's where you'd go be arraigned. That's where you could have your trial. That's where you'd be sentenced. If you appeal from a federal trial court, you can go to the appeals court level of the federal system, and from there you can appeal to the U.S. Supreme Court. Maine system has a district court and a superior court. Those are both trial courts, and they have different kinds of cases that they can hear. And all those red courts also, they have very specific rules about what kinds of cases they handle. But in Maine, if you want to appeal your case from the superior court or the district court, you go straight to the Maine Supreme Judicial Court, which is called the law court. In some cases, you could try to appeal a decision from the Maine law court to the U.S. Supreme Court. And there's plenty of other things that can happen, but I just kind of wanted to, I guess, finish the loop on our lay of the land here.
Thanks.
All right, I'm gonna jump back to our agenda. So if it's all right, I wanna do a little practice and talk about criminal laws themselves, statutes, and how they get constructed and how they're, how to read them, really, because I think that we should all be able to just look up the charge that we've been charged with and be able to see the actual text of the statute and look at it. But before I look at an actual statute, I guess we are going to look at an actual statute. I wanted to talk about crimes as a concept in American law. Every single crime that you can be charged with is made up of different elements, different blocks, and every single crime, well, let me back up. Each element of each crime requires different levels of proof depending on how restricted we're going to be. So by that, I mean, in order to stop you on the street, in order to search you on the street, in order to arrest you, in order to convict you, the government's going to need increasing levels of proof, right? That each and every one of the pieces of that crime were actually committed. So the pieces almost always fall into 2 categories, and almost every crime has at least 2 elements, a mental component and a physical component. And this is really, really important. And I'm going to show you in just a second kind of how you can see this in the statutes. But I wanted to talk a little bit about the mental requirement in criminal law because, well, so if we think about where this rule comes from, in general, our system of laws is not meant to punish people who haven't intended to do anything wrong, right? Who accidentally harm somebody else, who genuinely have no culpability for what's happened, right? And so we require that the government prove that you have some kind of state of mind that's culpable as well, right? That your thinking was responsible for what happened. And it can go to different levels, right? So knowledge and intent, for example, if I ball up my fist and I throw my fist towards your face and I make contact with your eye, it's not enough that I just made contact with you. It would also be necessary to prove that I meant to do that I balled up my fist and threw it towards your face on purpose.
Mm-hmm.
Recklessness and negligence are not necessarily somebody meant to do something, but you can still have a crime that requires somebody was negligent or reckless. And one way to think about that is basically you didn't have a careful enough state of mind. You weren't being cautious enough to be blameless for what happened. Does that make sense? So if you put yourself in a situation where something bad is pretty likely to happen, but we can't prove you knew it was going to happen, that can still be a culpable state of mind, right? Mm-hmm. And so there are a few exceptions. There are a few statutes that do not require any state of mind. And an example of that would be statutory rape. All the government would have to prove, right, is that one individual was a certain age and another individual was a certain age, and that there was this physical act, and so therefore that crime has been committed. Doesn't require a mental component. There are other very rare examples, but in general, you're going to see an intent requirement and a physical requirement. So let me just show you an example because I think that's easier. I pasted the entire because I just wanted to show you how big it is. This is our Maine's criminal code is all in Title 17A. You can pull up any statute. This is unlawful possession of scheduled drugs. I don't know if I said this before, but I just wanted to mention, I am not a criminal defense attorney in Maine. Okay, so I have not represented anybody on this specific charge. This is not my advice about how to deal with this statute at all. But I just wanted to look at it carefully and talk a little bit about it because I think it might help demonstrate some of the ways that criminal laws are written.
So Hillary, I just want to, it's really small on the screen. So
what if I do that?
Yes, perfect.
Yeah. Cool. So I zoomed in. The reason the whole thing was up there was just so you could see how long it is. This is the first sentence, okay? And this is the whole crime, really. The rest of it are examples and exceptions. So let me back up. These are lists. You can kind of see that it's lists, right? So it's lists of different substances. It's lists of different, additional penalties for certain facts. But if we just go straight to the heart of this statute, this is the actual sentence that tells you what offense is criminalized here.
Gotcha.
And I still think this is longer because all you actually are looking for, right? Let me cross out the first sentence because it's an exception. So we'll come back to that. The second sentence is telling you what the law is, right? A person is guilty of unlawful possession of a scheduled drug if we can cross that out because, we know that's what this statute is telling us is criminalized. The heart of this is just these four things that are underlined. These are the elements. I'm going to actually do one more thing. This is my little chart for this statute. So I went from that big long list of all those lists and words to just these four elements to show you we've got the person, right? So that's the person who's been charged. Our first element is their mental state. They intentionally and knowingly did whatever, right? This wasn't an accident. They were aware of what was happening. They meant to do this thing. So our next thing is the physical act, right? The possession. I'm not going to talk right now about the legal definition of possession, although there's a pretty interesting conversation to have there. But for now, I'm just going to say possessing, it's on you, right? Like you have control over that item. And you intended to have control over that item, right? You put it in your pocket or you put it in your car. Element 3, it says in the statute, if I go back, let me see, which is in fact a scheduled drug. So let me just, a scheduled drug for real I had a case once where the substance turned out to be brown sugar. And so if you can prove that somebody intentionally and knowingly possessed that item and they knew or believed that it was a scheduled drug, but it wasn't, then you have not met all 4 elements.
Mm-hmm.
Okay? And same with any one of them. So the government has to prove each one. They can't skip one of the elements. And so that is what it is required to convict somebody for the offense of unlawful possession of scheduled drugs.
So it's that they intentionally know and possess it, and that they intentionally and know that they possess the scheduled drug.
And that it actually was.
Right.
Right. So that requires testing, chemical testing. You can't look at a substance and be able to say beyond a reasonable doubt that it is, if you are looking at white powder, that does not tell you that it meets the definition of a controlled substance in Maine. Mm-hmm. And so if somebody is in possession of white powder, that person fully believes that they are in possession of cocaine. They think they are carrying a bag full of cocaine, but it turns out it's not. That does not meet the definition. And the other way around, right? If somebody has no idea that they're in possession of something and it turns out to be a controlled substance, but they genuinely had no idea, that wouldn't meet the statute either. Mm-hmm. So let me just quickly show you. This is the revision to the unlawful possession of scheduled drugs, right? So the bill that's currently been proposed is going to scrap that language that I just looked at, and it's actually making it not a crime at all. So let me just highlight some of the language on the right that jumped out at me. So first of all, we're going into a civil violation, which just is not a crime, okay? You don't have a mental state requirement with a civil violation. If you're speeding by accident, you're still speeding and you still owe a ticket. There's no mental state requirement. There's less proof required in order to find you responsible for the offense. In a criminal case, the government has to prove beyond a reasonable doubt that each and every element of that offense is true. In a civil violation, it does not require that level of proof. And we talked about this just briefly, I think, or maybe beforehand, I can't remember. So the statute, the new statute would create a $100 fine for a possession of a controlled substance. If you're unable to pay that fine, the next part of the statute gives the court the authority to refer you to treatment. I have questions about what that looks like. It says the court may refer someone. So may is an interesting word because it gives the court discretion. A judge is going to have a choice to make about whether or not this is an appropriate case for somebody to be referred to treatment. I'm also just curious if this is going to become a requirement under law or if it's a referral as an alternative to a fine. But if you're unable to make the referral or go to the appointment, would there be some penalty associated with that? I don't know. I mean, like I said, I'm not a legislator. I haven't read the legislative debates. There are probably lots of people who have and who can answer those questions. This is just my perspective looking at this and what makes me a little bit nervous about it. Mm-hmm. And the other thing that makes me really nervous about civil violations is that you have no constitutional right to an attorney in a civil case. So if you're given a ticket for possession of a scheduled drug and you're in front of a judge, you may not have the right to speak to an attorney before you enter your, response to the claim. So just some thoughts. I think we should be decriminalizing substances because I, in general, think that's a good idea. I just pointing out some things to keep in mind. So I did the same thing with the other statute, use of drug paraphernalia. Again, huge long list of examples and types of items that would fall under that definition. But again, you can kind of, I didn't cut the first sentence, but I did diagram it out a little bit. So on the left, you have the definition of drug paraphernalia. All equipment, products, and materials of any kind that are used or intended for use in, and then you've got a list of all these actions. So if you plug in any one of those words before a scheduled drug, right, and that item has been used, any item of any kind has been used or has been intended for use in planting, propagating, cultivating, growing, harvesting, manufacturing a scheduled drug, that is a violation of this criminal's code. You with me?
Mm-hmm.
So, well, and I haven't looked at the whole actual offense itself. I'm just looking at the definition of drug paraphernalia. And so the bill, LD 994, strikes the ones that I've put strikes through. Can you see that okay?
Yeah, so it's striking testing, analyzing, injecting, ingesting, inhaling, or otherwise introducing into the human body. So like syringes, pipes, test strips. Yeah.
Yeah. And so I think the title of the bill, I might have it up actually, is hypodermic apparatuses, I think, is an act to promote public health by eliminating criminal penalties for possession of hypodermic apparatuses. So I see this as like a really narrow decriminalization of a couple of things. Mm-hmm. And that's great. I think it is a good thing. That's my opinion. But I also just want to recognize it does not decriminalize all drug paraphernalia by any stretch. In fact, I just wanted to point out, so if you look at, here's some of those long lists of things from the statute. And I just highlighted a few where I could think of examples. So I struck out all of the sections that are struck by LD 994. Mm-hmm. So testing it, so you see D is crossed out, testing equipment used for use in identifying or analyzing the strength, effectiveness, or purity of scheduled drug. Great. And we've also struck all of paragraph K, which is behind all my pictures of the things that are not decriminalized. Mm-hmm. So you'll notice kits used or intended for use in manufacturing, compounding, converting, producing, processing, or preparing scheduled drugs. That's a, those words could be defined in a bunch of different ways, right? And I noticed isomerization devices. So that would be like a dab kit, maybe. Scales and balances, you see that in a lot of cases. Dilutants. So I put a picture of baby formula on here. That is something, I don't know if I can count the cases that I've had about baby formula, but mannitol, mannite, dextrose, lactose, different types of sugar, powdered sugars that are used for cutting. If it is intended for use in cutting scheduled drugs, then that would be a drug paraphernalia under the statute. Gin sifters used or intended for use in removing twigs and seeds from or in otherwise cleaning or refining marijuana. I must have missed something along the way, how that is still there. I could be wrong. I don't want to say with authority that is still in the statute because I'm very surprised to see it. But I put a picture of a grinder and blenders, bowls, containers, spoons. Spoons drives me nuts because it's a spoon. Capsules, balloons, cartridges, envelopes, Ziploc bags. It's all going to depend on the context where they're being found, right? But it's not clear, crystal clear in the statute, right? You know for sure now, if this passes, that a syringe, specifically a syringe or a test kit, would not meet the criteria. Mm-hmm. And I think, the just the thing to keep in mind and to like be aware of is what the law actually does say now, because even once a law changes, there's going to be a period of time when people aren't necessarily aware the law has changed, or how to necessarily distinguish which parts of the law have changed. You have the right to know that, and you should be very clear with yourself about, I'm now at less risk of being charged with a crime for this behavior. But that does not mean that, I'm at no risk.
Mm-hmm. Yeah, no, I think that that's so important, and like really calls on those of us doing harm reduction work and legal education work to continue to have conversations about what is still deemed paraphernalia in these laws and the ambiguity, because we know that folks that, are experiencing criminalization are going to be, and historically have experienced criminalization. People who use drugs are going to be more at risk for having these like pretty ambiguous concepts be used against them. And so I think that it's really important to kind of call out where there's still, there's still a lot of room for criminalization and a lot of room for education. So I appreciate that.
I'm going to talk, I think, we might, hang on, let me just look at, so in just a second, I'm going to transition away from this really technical legal analysis, but I lost my train of thought there, I guess. I was going to say, I know what it was. So one of the sources that I'm going to include and I'm going to refer to in just a second, the National Lawyers Guild is an organization that produces a lot of good know your rights materials and sources. So guides, pocket-sized guides in a bunch of languages. And they also produce, they have published something called the Jailhouse Lawyers Manual, which is actually a very helpful guide for federal cases, particularly prison condition cases. But anyway, NLG is great, and they produce a lot of really helpful information. They talk in their Know Your Rights guide a little bit about, I think, what we were just saying, or maybe getting close to saying, which is that just because the law says what it says does not mean that every police officer, probation officer, law enforcement person will know that or will honor that rule. Every single profession, just like lawyers and physicians and anything else, has people who are, bad at their jobs. And that's not everybody, but there are people who are bad at their jobs. And so you don't know necessarily going into any interaction whether or not you're going to have somebody that's complying with the law. Mm-hmm. Just like police officers say all the time, I don't know if I'm going to be dealing with somebody that's complying with the law. Likewise. So,
I think you see that a lot with the Good Samaritan laws surrounding overdoses and folks' rights in those moments, and how there's, there needs to be more education, and then also just a lot of systemic change and like revolution surrounding how we take care of each other, and how we are allowed to take care of each other in the legal system that we exist in. Because we know that folks are really, have a lot of fear in calling 911 because they are still criminalized. And so while we know that is a law that exists, it's also, our job in this work to really like address the risk and the fears that people experience on the day-to-day.
Mm-hmm. This is so why I think harm reduction is the set of values for lawyers. Like, I feel so strongly that I guess the first thing that I feel strongly about is that I'm not in a position to offer suggestions for change. I'm not going to put myself in the category of voices with lived experiences that I think should be at the forefront of advocating for change. So my role, my lane is very much, here's what the law says, and here's how I see it kind of playing out in real life. Mm-hmm. How we can revolutionize that, I have no idea. And I'm excited to see other people offer their ideas and for it to move forward. But what I do know for sure, and I do have lived experience with, is watching how people respond after a police interaction, particularly one that's been really bad or harmful.
Mhm.
And so knowing that that harm exists, recognizing that that is a real and present danger in the world for people, especially people who are low income or who use drugs, who maybe, because of the way that we criminalize behavior and poverty, you're just going to be subject to increased surveillance, exposure. And knowing those risks is the first thing to do to keep yourself safer, right? I think that's what harm reduction teaches me, right? It's like, know the reality before you move forward, because that just gives you the information, right?
Absolutely.
Okay, so my plan now was to shift gears a little bit. I want to talk about some of our constitutional rights, the things we've been sort of marching towards here a little bit, in terms of interacting with police on the street primarily. If it's all right, I would offer a little bit of a break for anybody or for you. All right, are we back on screen?
Very set.
All right. So hope you enjoyed those videos. I picked them because I think they brought a little lightness to the conversation, but also because I think they show a pretty broad variety of police interactions, and enough for me to be able to talk through a little bit in a way that I hope will be helpful. So I just want to talk very quickly about the text of the Constitution. We're not going to read the whole thing. So I just want to talk about the Fourth Amendment and the Fifth Amendment really quickly. So we've got the right to be free from unreasonable searches and seizures. You cannot be unreasonably searched or seized. Your papers, effects, your home, your person. The Fifth Amendment has a lot in it. There are a lot of things in the Fifth Amendment, and I'm not going to read the whole thing. I'm going to just point to this one clause which says, nor shall any person be compelled in any criminal case to be a witness against himself. And just to kind of bring you to the present day, it's been 229 years, or I think something. We can now see how these rules have been interpreted and amended, adjusted by case law, by statutes, by policies in a bunch of ways over the years, until we get to today, where this is a pretty good summary of these two rules that I'm talking about, right? Your right to not be searched or stopped unreasonably, and your right to remain silent and not provide evidence against yourself. So I pulled these 4 tips from the ACLU's Know Your Rights Police Encounters site, but I want to refer again to the NLG Know Your Rights for Law Enforcement Encounters booklet. That's going to be in the resource stuff. It's fabulous, and I think it does a really good job of talking about kind of reality versus the rules. So let me just read through these and talk about them a little bit, if that's okay.
Yeah.
Cool. So the ACLU recommends that if you interact with the police, you stay calm, don't run, don't argue, resist, obstruct the police, even if you're innocent or police are violating your rights, keep your hands where police can see them. Now, that is a little bit directy to me, like, you should do this and you should do this. The reality is that we don't know how we're going to respond necessarily. And the best thing that I can advise anybody to do is to just know yourself and know what your strengths and weaknesses are. We were talking about this a little bit this morning. I have a tendency when I'm under stress, especially if I'm panicked, if something has happened really suddenly, I have an instinct to start explaining and to start just talking and arguing and trying to defend myself. And I think that's actually a really common impulse to say, whoa, no, there's been a mistake. If I can just explain, if I can just understand what's going on, especially in cases where if you've sought help from law enforcement and suddenly you are now feeling like I was looking for help or assistance and now I'm under suspicion, when that flip happens, it's it's disorienting and it feels unfair, and it's really difficult to remember, at least for me, I can only speak for myself, just to remain calm. And so staying calm is a good advice, but in my mind, the practice is trying to just slow your thoughts down a bit, just to create a little bit of space, take one purposeful deep breath, because I think our nervous systems, I'm not a doctor or a scientist, the way our bodies respond to stress can sometimes give us the impulse to run or fight, right? Fight or flight. Mm-hmm. And that can get you in a ton of trouble and can be really dangerous. And so if you can work on trying to take a little moment of presence, grounding yourself in your body so that you are here now and you can hear your thoughts. Because, excuse me, at least anecdotally in my experience, folks will often feel like some things have happened really, really fast. Mm-hmm. And trying to go back and remember all the details of an interaction when it was a really high stress moment and it was a really difficult or scary experience, it can be really difficult to remember details and to remember what happened. That's why eyewitness accounts can be really unreliable, because our memories can play with us when we're under stress and when things happen fast. So I think staying calm is a general thing. I'm going to rewrite this into the second in the way that I would advise you. Ask if you are free to leave. If the officer says yes, calmly and silently walk away. If you're under arrest, you have the right to know why. I find that this piece of advice is often really confusing, because you're also usually being told you have the right to remain silent. Don't talk to the police. Do not talk to the police. Do not talk to the police. And then you'll see something that says, ask the police this question. Mm-hmm. And I'm always not sure if I should be advising people to talk or not talk. And I think the truth is I'm not there. The person who's in the moment is the best qualified person to decide what's appropriate and what's safe. And I'm never going to look at somebody and say, you did this all wrong, if what you're trying to do is keep yourself safe, right? And I also think getting as much information as you possibly can, especially in a scenario where there's a deliberate effort to keep information from you, right? To this, if you're under arrest, you have the right to know why. I feel like that's often not honored, right? Like, right. People are arrested all the time without a really clear idea of what the charge is. And it might be that, there's been an offense. We don't know if there would be another charge with that. So it can be really hard to keep yourself from, I want to stop generalizing like that. I think it's hard for me to stop in the moment and basically have a conversation, right, with somebody that you're in this suddenly very adversarial relationship with.
Well, I think like something that I hear you kind of like pulling out of these, I mean, like we're told so often in Know Your Rights trainings, like just like something as simple as stay calm, ask if you're free to leave, you have the right to remain silent. And in actuality, that's way more complicated than the directive, as you put it, kind of allows or recognizes. And that sometimes we are doing all of these things right, and someone's rights can still be violated. And so while we have, and we always want to have all the tools to make that situation the least harmful, we also know that systems are violent and that sometimes that harm exists even if we're doing everything right. And I think that that's something that I really appreciate you speaking to in this training and in our conversations before, which is like, there are best case scenarios and also things are just really chaotic. And so like, really like, what information do you need to get? And where also like, where's the nuance between getting the information, knowing that you should know why you're being arrested, and also not trying to over-explain or provide them with more information than they're even asking for.
Yes. Yeah. Yeah. I think, let me pause and say something else, which is we talked a bit at the beginning about the overlap of different legal systems and different sets of restrictions. I guess I'm going to come back to this because I don't have it articulated quite the way I want to.
That's okay.
I think I'm going to regroup that thought and come back to it.
That's fine.
Okay, so the right to remain silent. You have the right to remain silent. That's what it says. However, realistically, it's very difficult to get through any interaction with another person without communicating in some way. And I think even though it is not supposed to be used against you, that you have refused to answer questions or refused to speak at all, the law also allows law enforcement officers to make some decisions about the level of suspicion they have, right? And so you can use something like remaining silent or, refusing to answer questions as some kind of sign that someone's acting suspiciously. Mm-hmm. Now, I think the place and time to address that is court. It's really impossible to, have a legal debate with a police officer in person. And that's where these rules are really coming from, right? Like these guidelines or these suggestions, like staying calm and don't run, don't fight, don't resist. I think that my fear is that it sounds like just comply for your own safety, just comply. And that's not where I'm coming from at all. I definitely think like let me just move on to my next slide because I wanted to talk about a couple of just like themes that I wish I could convey if I knew somebody was about to have a bad police interaction. Mm-hmm. So yes, you have the right to remain silent, but first just sort of softening yourself so that there's this tension, right? This panic tension that, for me at least, it causes my thoughts to start moving really fast and to start trying to plan, where am I going to go? How do I get out of here? How do I get out? How do I do this? And that sort of spiral thinking, that racing thought, that can prevent you from absorbing information. And when you are the subject of a police encounter, what you are hoping for, right, is to gather enough information to know what's going on. And this is my theme of the day. You have the right to know what's going on. You have the right to know what's happening to you, right? And so if that information has not come to you yet, you should not be sharing any information. Why are you giving information to people who haven't told you, enough for you to know what's going on?
Yeah.
And the piece of advice about walking away, that's the biggest one for me. Like the one that I actually would give people that advice. Am I free to go? And if you are, do. Because if they follow you, if they ask you to stop, that is undoubtedly a seizure. And the test is whether or not you're free to leave. So if a police officer tells you that you are not free to leave, it doesn't matter if they put handcuffs on you. It doesn't matter if you're in a police car. If you are told that you cannot leave, you have been detained and you are in custody. For legal purposes of statements that you might make or any information that you might provide to the police, if you're told that you cannot end that interaction, you can't walk away from them, you need to stay put, anything that you're being asked about can be used against you later. That's true no matter what. But they don't necessarily have to give you the warning. And you've heard that warning before. You've heard it on TV 1,000 times. Anything you say can be used against you. People, in my experience, those kinds of statements that get used over and over and over, you have the right to remain silent, anything you can and will be used against you. It doesn't have a practical meaning in real life, because what does it mean to have something used against you? Until I saw criminal trials in real life, in person, seeing people's statements used against them, I didn't quite understand how that works, right? What does it mean to have something used against you? And if you remember back into the language of the Fifth Amendment itself, it's says that everyone has the right not to be a witness against themselves, right? To provide information. That's what a witness does, to provide facts and information against themselves. But if you've already done it, if you've already said something that could incriminate you in any way, that's in there, that you know, anybody could repeat that as evidence against you. And especially with this impulse that I have to start explaining what's going on, you know, oh, no, it's this, it's not that, it's this. You're offering information that nobody has asked for, right? And I think I've had lots of cases where somebody might have said something that they thought was really helpful, but what in fact it did was place them at the scene, you know? Oh, I wasn't doing X, Y, and Z. I was actually doing this. Okay, but the police officer before, or the investigator, whoever it is, might not even have known that you were there at all. But now you've given them that information. And I think, you know, again, slowing down and just sort of recognizing that this is not the be all and end all, right? This moment will pass, whether it's ending badly, you're being arrested, you're being taken into custody, or you're being released with a summons. Regardless, that interaction will end at some point. And there's this moment, I think, where I kind of have to remind myself, I will get another chance to be heard. Because I have this big fear that nobody's going to hear me, hear my story, hear my argument, hear my reason for this happening. I really want to get that across. I really, really, really want you to understand what I'm trying to tell you. And I have to. It is a conscious and really hard thing to try to convince myself, you will get another chance. You know, this is not the time to make that person listen to you.
Because you may be giving them when you are breaking down the laws into elements, you may just be giving them one of the elements that they can use to say, you know, you were, you know, even if it was just recklessness or neglect in that situation.
Yeah. That's a great point, especially with like intention, right? These mental states. How else can somebody prove what you intended unless you tell them? Well, there are ways to do that, but it becomes a lot easier if you say, you know, something about what the intent for use was.
Right. I want to give us a bit of a time check. It's 2:17, so we'll kind of wrap up in about 15 minutes.
I knew this would happen.
I think that this is like the start of our relationship with you too. And like, there are going to be other opportunities and more opportunities to have this education. And I think that that's important for folks who are taking part in this today as well. Like, if you have, you know, specific trainings that you want, or you want Hillary to come back and like talk about like, you know, really just, you know, searches, or talking just about bail conditions, you know, there's definitely an opportunity for us to all gather again. So just like to recognize that for those of you who are watching, and for those of us who are live streaming, that we'll have more opportunities as we wrap up in the next 10.
Thank you for the reminder. I have other things to talk about, but I also just wanted to offer the last few minutes if there's questions to talk through, because, you know, I was going to talk a little bit about right to counsel, some of the players in the courthouse, some tips about working with a court-appointed lawyer, other models that are tools folks can use when they're working with appointed counsel. Community defense and restorative justice, which are practices and philosophies that are rooted from and come from Indigenous communities and are finding their way into traditional American Western courts in really interesting ways, and I think really exciting ways. Talk a little bit about incarceration and supervised release. Specifically, I wanted to talk a little bit about MAT, cash bail, conditions of release. We can talk about that anytime. A little bit about punishment and why courts use certain models of punishment, and a few ideas about how we can advocate for sentences that are less harmful. Yeah. So any of these topics that you want to just touch on before I sign off?
I think we need to have a part two. I think that today really served as like, I mean, for me, kind of like this grounding in, you know, how are laws made? Who has the power to like, where is the power and where, and like, how do we map that out? Getting basic understanding of how, of what different interactions can look like. And from here, we can really kind of delve in, hopefully in the future, some of the, I think like the right to appoint a court-appointed lawyer and really conversations about, when you have a deferred disposition, when, you are being offered drug court, like different alternative sentencing, what are your rights in those moments? Because something that Hillary and I have talked a lot about is like, sometimes like there's the savior complex that can come up in the courtroom, which is I'm providing you with these opportunities, really in a pathologizing and criminalizing way. And so how do we regain autonomy and choice in these situations where maybe it isn't, it feels like it's like totally out of control. So maybe, I don't know, Hillary, if you want to like take the next 10 minutes and just kind of talk about that really briefly, and then we can use that as a point to kind of move forward in another conversation.
So going back a little bit to the like harm reduction theories, I think with sentencing, there are things you can control and there are things that you cannot control. And so again, it's about educating yourself and being aware of what you have control over and what you don't have control over. So if you know that ultimately the decision about your sentence is up to the judge, or it's written in the statute, there's a mandatory minimum sentence in this case, knowing which things you can't control or change allows you to navigate the best path for you around those obstacles. So knowing that jail time or incarceration at all is going to be part of the resolution of this case, knowing that early, or if you are incarcerated, maybe pre-trial, talking with your lawyer and thinking about, what that means for your case and how you're going to resolve it. Just first assessing the lay of the land, what is true, what is real, and what is not changing. And then from there, our practice in our office where I was trained was very much a client-centered practice. So our clients tell us what their goals are. And I think that's something that as a client, you should keep in mind, right? That you have certain decisions in any case that are only yours. A lawyer cannot make them for you. They cannot make them on your behalf without speaking to you. They are your choices, whether or not to go to trial, whether or not to take a plea, whether or not to testify in your own defense. So those certain decisions just don't get made by anybody else but you. And knowing how to use those choices, but also how to work with your attorney and trying to figure out, like, if my goal in this case is not sobriety, but it's to get this case closed, then that's the goal. That's what each court event is working to practice. So our clients tell us what their goals are. And I think that's something that as a client, you should keep in mind, right? That you have certain decisions in any case that are only yours. A lawyer cannot make them for you. They cannot make them on your behalf without speaking to you. They are your choices, whether or not to go to trial, whether or not to take a plea, whether or not to testify in your own defense. So those certain decisions just don't get made by anybody else but you. And knowing how to use those choices, but also how to work with your attorney and trying to figure out, like, if my goal in this case is not sobriety, but it's to get this case closed, then that's the goal. That's what each court event is working towards. And when the judge starts with, well, I'm trying to save your life, I don't know why you won't just do this. I don't know why you tested positive again. I don't know why you are you're not showing up to your appointments or IOP, right? Like, if you haven't showed up to IOP and you're getting a probation violation, suddenly that hearing is about how you let everyone down and they were trying to help you and it was disrespectful and it's personal and it's about shaming and humiliation. I've watched judges berate people for being bad parents because they've done something besides their required probation condition. As a lawyer, the only thing I can do to control that is prepare my client for what that's going to feel like. And to know that when a judge is taking out their disappointment on you, just remembering kind of, and we didn't have a chance to talk about this as much, but I find it's helpful to just sort of remember and remind ourselves that the people who work inside courthouses work there every day. And they work there over and over and over, and they hear the same kinds of cases over and over and over. And after a while, police reports and individual cases can just sort of feel like it's not this person letting me down. It's the 30th person, and now it's just wearing me out, right? I think burning out is something that happens to lots of people who have difficult jobs. And so when you do something like listen to stories all day, every day, suddenly you start to see things like they're excuses instead of reasons, or that they're failures instead of, just somebody living their life, and lives are messy. It's a little bit different, I think, when we're talking about cases where there's somebody who is the complaining witness, right? Who's the alleged victim, who is a victim of a crime. That can often create a different dynamic. And that's where I think restorative justice is a model that is exciting and also just hopefully moving away from the adversarial system, because communities are impacted not by criminal defendants or criminal behavior. They're full of people who might one day be facing a judge, or the next day might be needing the assistance, right? So people are multifaceted and nobody is just one thing. Knowing who you are and what your strengths are, and then helping your lawyer articulate those to the court. Also telling stories. How did we get here, right? What led us to this moment? Who are you compared, as opposed to the 50 other people I saw today? That's a little bit of a skill set. And I think one thing to ask your lawyer whenever, if I can give one last piece of advice, like knowing what the goal is during each event. If today's goal is to file this motion and argue it, great. If today's goal is just to get through the hearing, and so that you can sort of inform your lawyer's decisions and strategies with your goals, because it's your case. What are your goals? And making sure to check that your lawyer hasn't assumed what your goals are, right? If your lawyer is another person in this building who thinks that your goal is to get into treatment, but that is not your goal, then you should be articulating that with your attorney, who's required to keep that confidential.
And it just feels like, Hillary, there are so many, and I think that this is like so understood, but like there's just so many spaces for the system to totally go against and harm, someone who is moving through it. And so like, knowing that you have the right to, have your goal be the purpose of your attorney, that even if you have a judge that is looking to like save the day, if that isn't how your day is going to be saved, like really being clear on what options are, right? Like what choices do you have? Who is going to help you get to that choice? And if someone isn't helping you get there, what are your other choices? Like, how do you say, like, you are not the counsel that is going to help me in this, or I have been abused by this system? I think like knowing that at all levels, while people are constantly trying to, I think, take rights away and their subjectivity is shading, what is meant to be, or probably not meant to be, but is told to us as an objective system, is just like, a continuation of harm over and over again. And so, having the information, using the resources to be able to have your clear path I think is really important. And I appreciate you taking the time to kind of like start us in that conversation today.
And goals change,
Yeah.
Goals change.
And that's okay.
Yeah, absolutely. We're all works in progress all the time.
Mm-hmm. Well, thank you. I really appreciate being in conversation with you. I feel really lucky that you showed up to a naloxone training one time, a community training, and we were able to kind of start this relationship. So I hope that we can continue it. And thanks to everyone that was here, that spent time with us. Again, we will have another conversation on the 18th at 12 p.m. on harm reduction and reproductive justice and pregnancy for birthing people. And feel free to reach out to MAP if you want to have any conversation after this or to access harm reduction supplies. Thanks, Hillary. I really appreciate it.
It's just a pleasure. Thank you.